Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. Nice to see everyone. I am Justice Rubin, and I am lucky, and you are lucky, because to my right is Justice Englander, to my left, Justice D'Angelo, two of my outstanding colleagues. We will be hearing 5 cases this morning. There will be a change of composition of the panel after the 4th case. The rules of argument are, as they always are here, 15 minutes per side, and despite my wishes, no rebuttal. And what else would I say? If you're dividing your time, and I believe in one case the counsel is dividing their time, you should let us know at the outset what division of time you've agreed upon so that we can make sure the clock is set correctly. And with that, we will turn to our first case of the morning, number 23651, Commonwealth versus Lima. And we will hear first from Attorney Curran.
Good morning. Dana Curhan, may it please the Court, Dana Curhan for Joseph Lima. We challenge what we contend is an egregious Doyle error. I'm not sure if there's a Doyle error that isn't egregious, but I think this one is. The Court allowed the Commonwealth to elicit evidence of Lima's post-arrest silence. And the Commonwealth appears to concede that...
How do we know it's post-arrest?
How do we know it's post-arrest? I'm sorry, it was post-Miranda.
The only way we know it's post-Miranda is by the cross-examination.
The cross-examination, but also the nature of the questioning, I think raised some red flags. Officer Sheehan testified that after speaking with the complainant, she, quote, went and spoke with the defendant. Over objection, the prosecutor asked whether Lima asked any questions, and Officer Sheehan responded that, quote, he did not necessarily speak with me. I mean, he said words, but he did not answer any questions that I asked.
I mean, without Miranda, is there a problem? I mean, he's going to investigate. He goes and he asks a question of the person he's investigating. I mean, up till then, aren't we okay? He's not been Mirandized. He's not been arrested. It's okay. Hi, Mr. Lima. I have some questions for you.
Well, I think you know the final question, and this was over another objection, second objection. She testified that, quote, he did not wish to speak with us. Now, I think that raises red flags about, you know, is this, was some kind of Miranda warnings given? And I think maybe that should have been explored. And defense counsel, immediately thereafter, he did explore that, and he brought out the fact that there were Miranda warnings that were given and that he exercised his right to remain silent.
Can I follow up to Justice Englander's question? Let's assume Miranda hadn't been read to him. Isn't there still an issue? A police officer goes up to Joe defendant, investigating, says, I want to talk to you. Defendant says, I don't want to talk to you. I want to exercise my right to remain silent. Is that admissible at trial?
I don't think that is. I mean, there's a difference between what the Supreme Court says and what the SJC says. The Supreme Court says, well, that's not a constitutional violation if it's pre-Miranda. So if a police officer goes up to a scene of an accident or an assault or some incident and says to somebody, hey, what happened? Not knowing that, you know, he is a suspect, then, you know, it's like, I don't know, or he lies, or he makes some kind of statement. That statement is probably admissible. But in this case, you know, clearly the officer knew he was a suspect. The judge knew that the officer knew he was a suspect because she had just taken a statement from the ex-girlfriend. So she goes up and she knocks on the door and says, and there's some, she's a little vague. She just says some funny things about about how he handles it. Well, he said some words, but he didn't answer my questions. And he did not wish to speak with us.
The question itself is, did he answer any questions? The first question is, did he answer any questions, right?
The first question is, he did not necessarily speak with me. I mean, he said words, but he did not answer any questions that I asked, if that's what you're asking. And I think that's problematic, but it just gets worse.
When you went to speak with Mr. Lima, did he answer any questions? Objection.
Well, why would the prosecutor be allowed to ask that? When you went to speak with Mr. Lima, knowing, as the prosecutor has to be at least charged with knowing, that there had been Miranda warnings, the question, any question about speaking with him,
Right.
it
Exactly.
seems to me, has to be problematic. And these answers,
Exactly.
of course, create the implication of guilt, because an innocent person surely would speak to the police, except that he has a right to remain silent, so they can't be commented upon.
That's right. And I think the Commonwealth agrees. My sister will tell you whether she agrees or not, but from reading the brief, it appears that the Commonwealth concedes that this is a Doyle error. The argument is that...
I'm trying to understand where the Doyle error is. That's why I'm asking. I mean, you know, the third question is, you know, did he indicate that he wanted to speak with you? He did not wish to speak with us. That's a problem, right? But I'm trying to understand what...
I think the Doyle error is the prosecutor asked all of these questions knowing that Miranda warnings had been given.
Well, there's nothing that establishes that the prosecutor knew that. Is there? Not in the record before me.
Well, I mean, the thing is, this happened on pages 50 and 51. Also on page 51, the defense counsel brought out...
Right, afterwards.
Well, afterwards, but I think there were two objections.
No, but there's a representation that's just been made. The prosecutor knew this. And there's nothing in the record that indicates the prosecutor knew this when the prosecutor asked the question.
Do you think the police officer who gave the Miranda warnings knew it?
She may have known it because
Wait,
she seems...
the police officer certainly knew it, right? Because she
Police
gave the
officer knew.
Miranda warnings.
She gave the Miranda warnings.
So don't we charge the prosecution team of which she's a part with this?
We do.
I assume we have to clarify, or you want us to use it as a Doyle error so we don't have to find prejudice. Let's for a second say we don't find there's a Doyle error and it's just an objection, which I guess I'm tipping off the prosecutor is what I'm going to ask is the relevance of the question. Even if the answer is he remained silent, and I know I'm paraphrasing, what's the relevance of that question? And now let's get to, if it's not a Doyle error, what's the prejudice?
I think the complainant was not a particularly good witness, and she went into the police station and said, "Hey, this thing happened 3 months ago. I don't know where the cat. I don't know what he did with the cat." And then she's sending him texts saying, "I wish the worst for you in life," and there's clearly some hostility there, and that's probably why the officer wanted to go get his side of the story. But you're looking at this, and you have a case that is, if the evidence is sufficient, and we actually contend that it isn't, but it is barely sufficient. Now, you have a single non-credible witness. You have no physical evidence.
Well, I was going to ask you about that, but I'll let you finish your thought, and I'll come back to physical evidence in a moment.
Okay, so, but there's no physical evidence that the officer has. There's a representation to the officer that she saw some specks of blood on the bathroom floor. Okay, so, but she's saying this, but she stayed with him for 3 months, so there's some real credibility issues with him, with her. With her.
And there's no cat.
And there's no cat.
That's physical evidence, isn't it? There used to be a cat, now there's not a
There
cat.
used to be a cat, and there's no cat, but who knows? I mean, if...
Maybe
if
the
I-
cat ran away.
Maybe the cat ran away, maybe he gave the cat away. Who knows what happened? So the judge, any finder of fact, in this case it was a judge, is looking at this and saying, you know, this is not a strong case.
So the standard is harmless beyond a reasonable doubt, right?
It's got to be harmless beyond a reasonable doubt.
Okay, and where would you point us for the cases that you would rely on to help us evaluate whether this error, assuming it is error, is harmless beyond a reasonable doubt?
I think I would look at Commonwealth versus Mahdi, and the quote is, "The nature of a Doyle error is so egregious that reversal is the norm, not the exception." And I think in this case...
Yeah, but it gives us a 5-factor test to apply, and then Judge Kafka applies it, and I can't remember which case, and he concludes that you can be harmless beyond a reasonable doubt, depending on the weight of the evidence and the other factors, right?
It can be if the judge, you know, there's, and I know the Commonwealth talks about there's a presumption that a judge instructs herself correctly, but the judge here, over 2 objections, let this in for its full probative value, and then when it was brought out that Miranda warnings were...
And hard to say the judge instructed themselves correctly when the judge incorrectly allowed the evidence in, right?
That's right, exactly, and the judge never struck it.
Yeah.
And
Was the judge asked to strike it afterwards?
judge wasn't. Now, let me say this. This was not anybody's best day. As far as who did the best job, I'd say defense counsel, because at least he was objecting and he focused on the issue and he brought out that Miranda warnings were given. The judge did not do a particularly good job. The prosecutor did not do a particularly good job. And I think there's a very real possibility that the judge, having admitted this substantively, then considered it substantively and said, well, he's not telling his side of the story.
Nothing in the record that indicates that, right? We don't have any findings by the judge. We don't have any of the judge's rationale for finding guilt, right?
No, this is a 61-page trial. Probably 10 minutes after this happened, the judge is finding him guilty and sentencing him.
Well, if since the objection was not sustained, it was not struck, then if we follow our precedent, the judge could consider it for whatever its substantive value is, which
Exactly.
he could infer that the silence was prejudicial to the defendant.
Yeah, and I think, I don't think you can assume that the judge said, you know, had a change of heart and said, oh, I'm going to strike that. If she did, she probably would have said, oh, Miranda warnings were given. I'm going to strike this whole thing, because throughout the trial, she was sustaining objections and striking evidence that was inadmissible. So I think we have to assume that the judge considered this...
Does it matter that defense counsel, after defense counsel brings out that Miranda had been given, does it matter that defense counsel then didn't say, Your Honor, I want to strike what was previously testified to?
Oh, it would have made my life easier. And it probably should have been done.
So that comes back to my very first question. I'm trying to just understand the whole scope of this. If we didn't know, if Miranda had not been given, okay, if Miranda had not been given, was there any error here? Would there have been, I have to ask it that way, would there have been any error in allowing the evidence in?
I think you would have to go through an analysis of whether, things like whether he was at that time a suspect, and therefore had, you know, maybe it was custodial because the officer was at his house.
Knock on the door, he opens the door, you say, hi, Mr. Lima, how you doing? I'd have to ask you a few questions about your cat. And then, what did he say? Well, he didn't want to answer my questions. That's not a Doyle violation, is it?
Well, without Miranda, that would not be a Doyle error. Now, the SJC has said, you know, the Supreme Court says that's not a problem. The SJC has said it can be a problem.
What's I'm sorry, you go ahead.
Can be a problem on a pre-Miranda, pre-arrest, non-answer going into evidence.
It can be if you are, if they found a dead cat out there underneath the balcony and they knocked on the door and said, do you know anything about this cat? And he said, screw you, I'm not answering any questions. That might not, that wouldn't be a Doyle error. And it might not be, then you'd go through an analysis as to whether it's common law, you're not supposed to do that, rather than Constitution, you're not supposed to do that.
Well, hasn't the SJC also characterized it as an evidentiary error? If a person says, I don't want to talk to you, forget about Miranda, forget about even when they're a suspect. If they say, I want to remain silent, or words to those effect, the SJC says that question and answer has no relevance.
Yes.
So what would, if we find no Doyle error and we just go to it had no relevance, what's our standard at that point, and how does that help you?
Well, it was objected to, and I think it's evidence that really shouldn't come in. So, I think we're still, was the error harmless beyond a reasonable doubt? But, we know it's a Doyle error because it was brought out that Miranda warnings were given.
Right. I told you I wanted to ask you about the physical evidence. You make an argument that it's the confession only that convicted, and we can't allow a conviction on that. What about the blood? Isn't that the plus? I mean, it's a very thin line. Isn't that enough?
I'd say it's not enough because the complainant couldn't say, very little blood, and the complainant couldn't say, I don't know whether it would, or it could have been him cutting himself shaving. Unless there are any further questions, I'll leave the remaining points to the brief.
I see none. Thank you for an excellent
Thank you.
argument. And we will hear next from Attorney Burbine.
May it please the Court, Carolyn Burbine for the Commonwealth. It's our position that the questioning, that the first question, when you spoke with Mr. Lima, did he answer any questions? Did he speak with you? That one. We can't tell if that's pre or post Miranda, so that's not Doyle. The other thing I would like to point out is when the defendant voiced his objections, he didn't give the reasons for the objections.
He's not required to, is he, unless you're not sure what the judge is ruling on?
I went along with harmless error, but I mean, the rules of evidence, I feel that to really perfect your objection, it should be, the reason could be given. So,
Well, I think
for
there should
example,
be, I actually agree with you, there should be a rule like that. I thought the rule said you weren't allowed unless the judge asked.
I'm sorry, you weren't allowed to?
Weren't allowed to explain the basis of your objection unless the judge asks. I thought that was a rule. I may be mistaken.
I'm not positive, Your Honor. I thought it was just to preserve it, you should do both steps.
Well, we can look at
But,
both,
No rule that says you're not allowed. Judge
Can I
sometimes
accept
will
your
say that he
argument?
doesn't want you
yes.
to.
For a second? Well, let's just stick to common evidentiary rules here. What's the relevance of that question if the answer is, basically, again, I know I'm paraphrasing, he remained silent?
Well, the first part of it was, did he answer any questions? Did he speak with you? So I still think that that's sort of part of her explaining that the police didn't just cease their investigation when they talked to the victim. They actually went out and spoke to the defendant. And I think that's important for a fact finder to hear, that they didn't just say, oh, she said it, well, now let's go arrest him. They went and tried to talk to him.
So let's, again, I'm trying to follow your path here. Let's say the words were legally significant. Did you speak to the defendant? The defendant responded, I am exercising my right to remain silent. Would that be admissible in any circumstance?
If we're talking post-Miranda.
Oh, pre-Miranda.
Pre-Miranda, I think some conversations can be, this is a reference to silence. It's not a Doyle error. I think if the
Do you have any case that you can point me to that says when somebody says, I want to remain silent or I don't want to speak to the police, that that's admissible for some reason?
Well, no. I mean, I have But we don't know if that's where she was necessarily going. It's bad questioning, as counsel, my brother pointed out. It's
And there was an
police
objection,
officer didn't even.
and it was overruled. That's part of the problem.
Right,
I mean,
but we-
you didn't really answer Judge D'Angelo's question, which was put in terms of, I want to invoke my right to remain silent. If that's what he said, that doesn't go in evidence.
Right. Well.
That's not what he said, though.
But that's
Not what the evidence
said.
was.
We don't have a clear, I don't think we have a Doyle error because the answers and the questions and the answers are not as explicit as you have with Doyle.
You've mentioned the first question,
Right.
but I take it the second question is a harder case for you.
The second question's harder, but I still think that the judge at this point is not necessarily certain where the prosecutor's going with this. Now, defense counsel, by raising the questions that he did on cross, showed what he thought the prosecutor was doing. I'm not sure that the judge at this juncture can tell if we're talking about pre-arrest, post-arrest, what's going on here.
How about the
So-
prosecutor? Don't we have to give some weight to the prosecutor knowing where, I think in this case it's a she,
It's a she.
is going? She's supposed to know what the answers to the question are before she asks the questions.
Right, but as my brother pointed out, sometimes the questions are not as well phrased as they should be. But let's just say,
Right,
for
but
the
that's
sake
her
of
problem,
argument.
too.
Right, but say for the
okay?
sake of argument, this shouldn't have come in. I think it's very important to note that the prosecutor did not ever, she didn't continue with this line of questioning. She didn't ever
She
use
got the
it.
whole line of questioning in. What do you mean continue? She finished it.
Well, I mean, no, I mean after this. Like
She
never-
finished it. Why would she go on with it? She got the answers she
Well, she
needed.
didn't start talking about knocking on, anything about pre-arrest, post-arrest, Miranda, anything like that.
Right,
just-
she didn't put in what would have been important. Instead, she went right to getting out the fact that he hadn't answered questions when she'd come to, it really goes to Judge D'Angelo's question right off the bat. Why is she asking these questions? Because it sure looks like she's trying to get in the fact that he didn't say anything.
Well, because, but, all right, well, let's just say that that's the case.
No,
Then-
can we answer that question?
Well, then
What
that's why I would.
What is the purpose of asking the questions she asked if it was not to simply get in the fact that he had not answered questions?
It's reasonable to infer that that's what she was doing. I can't deny that, and I
So then we
stated that
need
in
to
my
go to a
brief.
harmless
So now
error analysis,
well, we're in
right?
harmless error if it was an actual objection. If you need to have the objection and the reason, then I would say substantial risk.
I don't
You
know if
can-
we have to have the reason.
But I would just raise that, because I didn't make that distinction in my brief. I'd
All
just
right,
like
so
to do that.
harmless, and I thought your brief was
So-
good insofar as it didn't push too hard on this, not an error, and there was a lot of if it was an error. So if it was an error.
If it was an
At the
error.
end of the day, I take it your argument comes down to harmless beyond a reasonable doubt.
My argument would be under either harmless error or substantial risk. She didn't raise it in her closing. She never brought it up.
Okay, and it's not just harmless error. If it's an error, a Doyle error, it's harmless beyond a reasonable doubt.
Right, if it's a
Okay.
Doyle error, but it's not, I'm also arguing it's not a Doyle error. So in her closing, she didn't compound the error.
I don't understand that, and I apologize, but the argument is that it's not a Doyle error, but it's an error.
I'm sorry, the first portion wasn't it? Well, it's not a Doyle, well, Doyle dealt with it was where the defendant was impeached with his statements, and here the defendant didn't
And
testify.
take the stand.
Right.
So you're saying it's not a
So-
Doyle error because it's not in the context of impeachment?
Well, I'm saying, I mean, if it was used to,
But isn't the question, for purposes of our standard of review, the question is whether it's constitutional error?
right.
And in our cases, Mahdi, is that the way you pronounce
Mahdi.
it? Certainly suggests that certainly holds that it's constitutional error to comment
on silence.
on silence.
Right, because if it's used for consciousness of guilt, yes. And
Well, let
So
me
my
ask,
point-
let me ask about that. Putting aside Doyle error or not, because of the way it came in, I think we all agree, everyone here, improperly it came in. But the judge then, pursuant to our precedent, can consider it improperly for its full evidentiary value, meaning she can use it against the defendant.
Right,
So
but
how do we get around that?
I think when defense counsel, I still think, since it wasn't clear whether it was pre-arrest or post-arrest, or when Miranda was given, and all of that, the judge still may have been, But when defense counsel
I'm sorry, the
clarified-
judge may have been what?
I'm sorry, may have, you could have an opening to say, well, we can't be sure what the judge's thoughts were on. I would argue that we still can't be sure what the judge's thoughts were on this. Then defense counsel, clarifies for the judge with his questions on cross what his concern was, which would be right to silence. At that point, the judge is now clued in to what his objections, for certain, what his objections were about and what his concern was. And now I believe that we can, the judges are presumed to know the law. They're presumed to know.
So we're to presume or infer, and I'm looking at page 51, that after the defense lawyer makes it pretty darn clear that Miranda is at issue, without moving to strike, without the judge interjecting, oh my gosh, I'm sorry, I'm not going to consider all that evidence, we should just infer that in her mind she did that?
The judges are presumed to know the correct legal principles, and I would point to Marungo. And in Marungo, it was a bench trial. The judge, there was a motion in limine over who should be the first complaint witness. They did a voir dire of a woman, and they decided that she should be the first
So
complaint
this is an
witness.
error that's permissible in bench trials?
Well, if I could just finish her, I'll
Sure.
get to it. And so as she testified, they realized she's not really the first complaint. Judge changes his ruling, allows a different person to be the first complaint witness. He's not asked to, and he does not strike the first.
So it's in and he
witness's
can
testimony,
consider
and
it.
the court
And
presumes.
you've just said, we can't tell what he did with it. Did he count it as anything or nothing? We can't tell.
I think once that the judge was clued in, we can presume that she would have known the
But
law.
you said first that we can't tell what the judge did.
Well, you can't in Marungo either, but the court said, while he should have stricken the testimony of the first one on the record, and he didn't, we can presume that he disregarded the first.
But we don't need just a presumption. We need beyond a reasonable doubt. No one's ever been convicted on a presumption alone, I
No,
don't
but
think.
I'm talking about a judge instructing
Is your
himself
point that
properly.
if we were to follow your logic, that in fact the judge in her mind struck the testimony?
Yes, as in Marungo.
Which brings it closer to Judge Kafker's opinion in whichever case that is. where it was
I think
actually
Marungo is on point on that. We're to presume that the judge disregarded that first witness's testimony because judges are presumed to know the law. So once the judge, it was clarified in the judge's
So the judge is
mind.
presumed to know the law that she should have not considered the evidence, but we shouldn't presume that she should have sustained the objection to begin with, because she didn't. How do we do both?
I still don't think that, given that brief exchange and that, the lack of clarity in the questions and the fact that we don't know if we were talking about pre-arrest or post-arrest statements from that conversation.
So you agree that the lawyer properly objected at the time the prosecutor was
I
asking
agree
the
that he
question?
objected, but he didn't state the reason.
Okay. So what he should have done was, in your argument, I guess, after he made it clear that this was post-Miranda, he then should have told the judge, I now want you to strike.
Yes.
No,
He should have asked her to
nothing the
strike.
prosecutor should do at that point either? And say, oh, Judge, I made a mistake, I shouldn't have, you should strike that? Not just stays there and says silent, right?
It would be, as my brother said, it would have been helpful had we had situations like this, but I still don't believe that you can assume that the judge did not correctly.
Under your theory, you don't care what defense counsel did.
No, he objected.
Let me finish. I'm just playing this out, because that's, under your theory, the judge figured it out on her own. Because once she was told that Miranda had been given when this discussion took place, she then said to herself, aha, that that objection actually was a good objection, it turns out. And I now in my head, because I know that Miranda had been given, I strike that evidence, and therefore, and we should presume that that's what the judge did, because we have case law that says that judges know the law and are presumed to follow the law. That's your argument. It doesn't matter what defense counsel did under that argument.
I still don't think you can assume from the get-go that she didn't know, but what I'm saying is, if she didn't know, that then for certain it would have been.
But if we don't know if she didn't know from the outset, then we're back to, we can't say beyond a reasonable doubt it was harmless.
But I don't think you can ever know with these bench trials, and that's why we have the case law that said says.
Well, I
very
kind of
strongly.
think if a judge realizes that there's improper material in the record, she's going to say something into the record. I now realize X, or, oh, I hadn't understood that was what had happened, or
Well, maybe the fact that she didn't shows that she knew all, that
she
just.
secretly knew.
It's just, we don't have the record. I mean, the record is what it is, I guess is what I have to say. Did the court have questions on the second? I did want to point out on the second issue, I think we don't just have the blood. I mean, we have the cat wasn't there. She never saw the cat again. We had the blood on the bathroom floor. I didn't point this out, but I thought of it as I was preparing. There was a reference by the woman that the defendant had told her he would like to do something nice for her with the collar, which means they have the cat's collar. Now, that's odd if you have no cat, but you have a collar. So I just wanted to point that out. And also, I didn't reference, and this is also in the record, they lived in a third-floor apartment in a complex. So, I know the defense is saying the cat could have run away, but that's, I think, less likely to, given the location of the apartment. Did the court have any further questions? No?
I see none. Thank you very much for an excellent argument. The case is submitted. The next case we will hear is number 23-398, Commonwealth versus Gary. And we will hear first from Attorney St. Lawrence.
Good morning, may it please the court. Tim St. Lawrence for DAVAUGHN Gary. In the brief, we cited two main reasons why the police did not have reasonable suspicion to stop Mr. Gary. I think I'll start with what I think is the simpler reason, and that's that when the police pulled over the rental car, the rental car on March 25th, they did not have reasonable suspicion to believe that the driver of that car was driving that car or in that car 2 weeks earlier when the alleged crime occurred in that car.
Counsel, can I ask you something about the record itself? And maybe I missed it, but I can't find exactly what the bolo was. I have the police reports that sort of paraphrase things, but the way I read the transcript, the officer looks on his computer terminal and there's a bolo. Do we know exactly what that police officer saw on his computer terminal?
No, the exact bolo was not entered in evidence. I believe the police officer, the Boston police officer, refreshed his recollection by referring to his report.
Right.
But other than that, all we know was what he testified to at the hearing. But the reason that we don't...
He testified at the hearing that the bolo made a reference to brandishing a gun, right?
Yes. Okay. So they understood that a person in that car 2 weeks earlier had allegedly brandished a firearm.
Well, I guess we also, whatever was known by the other police department is imputed to this officer, right?
everything that was entered into the motion at the motion to suppress
Yeah,
hearing.
of course, it
Yes,
has to be
yes.
in the.
So, absolutely. But what Foxborough didn't do in those intervening 2 weeks was investigate who was renting the car, identify that person potentially, and ascertain the terms of the rental agreement. So was this a rental agreement that would still be in effect 2 weeks later, or was it?
But why did they have to do that? I mean, the question is, you say, your first argument is basically the BOLO doesn't give them reasonable suspicion to stop the car because they don't know who would be driving it.
Because it's a rental car and it's 2 weeks after the alleged crime occurred in the car, they have no,
Well, but
it's not a
don't they
reasonable
have-
inference.
Reasonable suspicion is a low bar, right?
Sure.
Don't they have reasonable suspicion to stop the car and say, hey, we have a report that this car was driving extremely erratically 12 days ago or 13 days ago, and that somebody brandished a weapon. You know anything about that? Don't they have reasonable suspicion to do that?
No,
Really?
they do not. No, that's not a reasonable inference. It has to be individualized suspicion. So,
No, I'm stopping the car, and I'm asking whoever's driving it, hey, you know anything about this? Somebody committed a crime in this car 12 days ago.
you're stopping the person in the car. You're not stopping the car. So
It's not the car that was operating recklessly or negligently. It was the person driving the car.
right.
I may be wrong, but I don't think cars have constitutional rights.
I would agree with that.
It's a tough one, but
So I think without that information, 2 weeks later is certainly out of time. Whether they, if the car
Now,
was,
what information? What else did they need?
they need to know, they need to have some information that the person driving that car on March 25th, 2 weeks after this alleged crime occurred, was also driving or in that car.
But, sorry, it's a cart and a horse thing, right? I mean, they stopped the car, and that's exactly what they did. They confirmed, the first thing they confirmed was that this guy was the person who had also had the car under rental for the last month.
Right. But
And therefore was, at least inferably, the person who was driving the car 2 weeks before.
and if they had stopped him after he'd answered that question. it might
Yeah, I
have
think
been-
it's at the moment, so the moment of the stop was, that's where we cut off any,
You say it's a rental agency. Do we know anything in this record about this rental agency?
only the name, of
We
it.
literally don't know where it is.
Not in the
I
record.
just want to double check to,
I don't think in the record we do either, but if we did, that might make a difference.
right, I believe it is only the name of the rental agency.
I'm really not sure I understand this argument.
Okay.
So, if the car had been stopped that day, we're fine, right?
I would probably
It's a
concede that.
staleness, it's a staleness argument. 12 days is too long to stop the automobile.
Especially when it's a rental car.
It's a rental
It
car.
might be different if there's one person registered to that car,
Was the argument presented to the judge as reasonable suspicion had become stale by 12 days? Was that the argument that was presented below?
Yes, that was certainly raised below.
You just conceded something, and I just want to make
Okay.
sure I can follow that. So if the car had been stopped later on in that same day, I think it was March 13th, you're saying reasonable suspicion would have been there?
I would still be, if that were the case, I would still be arguing it wasn't, but it would be a far closer case.
Let's keep going with it wasn't.
Okay.
Because I want to, and maybe this is the second part of your argument, and your time is getting a little low. Let's talk about Oscar, the informant. We'll call him the informant. My question, again, I guess I'm tipping off the prosecutor what's going to come. Can somebody be reliable initially, and then the police learn pretty quickly that he's no longer reliable?
Yes, yeah, reasonable.
Any cases? Because I can't find any where that's happened.
Well, it probably would be more in likely to be found in kind of CI cases.
And I looked. What I have in this case is, maybe, in a light most favorable to the Commonwealth, we have the name of the person and the phone number. Some of our case law says that establishes reliability. Some, not all, but some. But then, a few days later, Oscar says, I'm not talking to you. I don't want to have anything to do with you. Does that cut out the reliability of Oscar at that point, when you know who he is, but he's saying, I'm not giving you any more information, I'm done?
That's the argument we make, absolutely,
Why does that affect his reliability when you have his phone number and you know it's his, or you know it's a phone number that works, because when you called him, he called you back 25 minutes later. You know how to find him. Isn't that the whole point of reliability in these cases? Isn't that what I think it's Westfall that came down like a year
Right,
ago says?
and I see that in cases where the police don't have time to verify anything. We can kind of have a legal fiction here that this person gave their name. Well, first of all, I don't think name is enough to make someone, even when it's a common name such as Oscar Flores, really doesn't make them identifiable. I don't think he gave his number. I don't see that in the record. They had his number.
How could they have his number if all he's given is a name? I mean, you think they typed in a name
No,
and found a number?
I think the system probably retrieved his
That
number
seems
when
bad
he made
for
the
you.
call. Well, we don't have the 911
I agree
call.
with that, and we don't have a
Anything
computer, but a
about it.
database, police database that has his number probably has some more stuff about him. They didn't put anything like that in, so I don't think so. I think he gave them his number.
Sure,
And then the question I have is, we don't know that it's a landline, we don't know that it's associated with his name, we don't know that it's associated with an address. Does that make someone reliable? I mean, I have tried to find, in the old days, although it was a little tricky, if you had someone's phone number, there were databases, you could find something about that when it was a landline.
Mm-hmm.
You could put your friend's cell phone number in Google, till the end of the world. I don't know if the police, I would hope they had something better, but I don't know. And I don't even know if the cell phone company knows, because it depends, I guess, if they're sending a bill or if it's, just a prepaid phone, I don't know. Do we have any case law about that?
about the advances in technology.
Well, just about whether a phone number alone it renders someone more reliable. I mean, there are cases, but I feel like I don't feel like anyone's addressed this.
Right, and then
all you have is a phone number, and maybe in 1965 that would have been primo. But now it could be virtually useless.
Right, and I think in a fast-moving situation, the courts would probably say, giving over your name and phone number, you have made yourself identifiable and thus reliable.
You think he's identifiable because they have his cell phone number?
Isn't that what Westfall says?
Right, I think the case,
We have a case
I don't know.
that says this, I think. It's about a year old. I was on the panel.
Okay.
It's a little bit different because Westfall might have been named date of birth, which I think is probably stronger identifying information.
You're right. There may have been a little more
Right.
data. My memory of Westfall is that it says name and phone number, but it's more than just giving his phone number. He called back. So not only did this person give his phone number, he responded to calls to that phone number, and whoever it was on the other end of the line knew exactly what they were talking about. He confirmed when he responded, I'm the guy who called you about what happened, because he said, I don't want to talk about it anymore. I've told you everything I could. That all happened, right? Isn't that enough for a reliable witness? I mean, the problem I have with it is if you say he's not reliable, it seems to me we're going in a direction we really don't want to go in, which is the suggestion that an ordinary citizen who calls up to report that someone brandished a gun at them on the highway is not enough for you to stop their car.
Well,
How can that possibly be a good idea?
I'm willing to concede in a fast-moving situation, if they had come upon the car where Oscar said it was going to be, they've now corroborated some of what he said. They may notice there's 3 black men in the car, further corroboration. So in that fast-moving situation, the cases talk about when it's the timing and the distance, so he would be reliable. But when you have 2 weeks to get more information from...
Wait, do we have any cases that suggest there's a different test for reliability if you had more time to get more information?
I think just like reasonable suspicion, it can dissipate, especially when someone refuses...
Nothing has dissipated. It's not a matter of staleness. I mean, if a year passed, maybe it's no longer his phone number, right? I could see something like that. But chances are, in terms of reasonable suspicion, chances are a phone number that worked 6 days ago or 8 days ago still belongs to that person, right? I don't see how...
Right, but there has to be a situation where police determine that the person that called is not who... If they call that number and it's...
But I don't... yeah, certainly
then
for
it's
probable
dissipated.
cause, I don't understand. I haven't seen a case. I mean, I've seen a case I don't understand from the Supreme Court that says if it might be a bomb, you need less suspicion, which seems like a non sequitur to me. But I don't think I've ever seen a case that says, oh, but you had more time to investigate further and didn't, and therefore this would have been reasonable if you were a cop driving on the highway. But if you're sitting in an office, it's not. I've never seen that. I'm not saying it's not right. I'm just saying, do you have a case for it?
I think you can look to the cases that say a caller is identified, identifiable, or anonymous. That can change when the police cannot identify the person. So if the person's identifiable at a certain time, now we've had time to try to identify him. To
How much longer
speak
did they,
face-to-face with
how
this
much
person.
later did they call him?
They called him an hour and a half later. He did not return
Yes,
that
I'm aware
call.
of that. And then when did they
5
call
days.
him?
Then they called him 5 days later.
5 days later, and
Right.
it's still his phone number and he's still at it.
Right.
But you think 5 days after that, who's to say?
Well,
Isn't the touchstone of reliability that then the police can do follow-up to speak to the person? Isn't that the
Yes.
touchstone of reliability?
right.
So I
They
go
can't-
back to my initial question. He's reliable at first. They know, maybe. Name, telephone number. But then he says, I'm not talking to you. The investigation regarding Mr. Reliable is done. He's saying, I'm not going to give you any more information. So can he be reliable initially and then based on his own actions, stop being reliable?
Yes, absolutely. It can dissipate. He's refusing to give any real identifying information. He's refusing to even say which person in the car.
Whoa. No, he said, I'm not going to come into the police station and I don't want to talk to you anymore because I've told you everything I can. That's not refusing to give identifiable information, is it?
I think the judge found that
He's an ordinary citizen who's saying, you know what, I told you everything I know, and I don't want to do any more on this, which is, he has no obligation to, nor is it particularly troublesome, is it? I mean, that's not an uncommon reaction.
Right. You just have to ask the question then is, what is this case then? If we
Well, but
have
how
no
does it make
victim-
how does it make him unreliable? I mean, we have a different question, which is whether it's become stale, and that was the first question you started with, right?
Right.
But I don't know how it makes him unreliable.
I just think it's
We need
new
to keep
information that casts doubt and makes him questionable when he's refusing to show his face. Thank you.
We will hear now from Attorney Sicanolfi, whose name I hope I pronounced roughly correctly.
Yes, thank you, Your Honor. Good morning. May it please the Court. Kyle Sicanolfi for the Commonwealth, asking this Court to affirm the denial of the defendant's motion to suppress. On the issues of whether Mr. Flores' report could be considered reliable, both for his basis of knowledge and where this panel has focused more intently on his veracity, much as Justice Englander just referenced, the fact that he did not present himself to the police station in the immediate aftermath of having made the call, and the fact that despite returning police call making himself accountable to them and stating, I have nothing further to add, that without more doesn't give us any reason to question his reliability, which Justice D'Angelo expressed is sort of the concern. Did something about his behavior after the initial call his reliability into question? And that's just simply not here in the record. There's nothing by way of a recantation or a suggestion that he sought to tell the police they had it wrong. He simply stated he had nothing further to add. And he was accountable to police who used the name that he gave and the phone number that he gave to reach him and were able to do so days after the fact. So I don't think his declining to participate further as days wore on cast doubt on his reliability.
Do you have a case where that's all there is for reliability?
Can I ask, Your Honor, what you mean that's all there is? What you
A name and a working phone number.
I think the Westgate case, if I'm remembering the name correctly, that might have been referenced in prior argument, I think that in that circumstance, it was a 911 caller who gave a name and had an identified phone number. I don't believe there was any indication that officers encountered them personally at, the scene where they conducted
Well, the other
a motor
thing that
vehicle
happened in
stop.
Westgate, which also happened here, as I read everything, is that in Westgate, the person stayed on the line and described what was happening in front of their eyes. And in this case, Flores apparently did the same, as I read the police report. What do you say to Judge D'Angelo's question about what the bolo said? Is there any evidence about that?
Yes, in the transcript at page 27, I believe it's Officer McDonald who testified that querying the license plate, he saw the bolo that someone brandished a firearm in association with this particular vehicle.
So that's it, though. But we
That's-
don't know anything about whether they know anything about Oscar. And I know there might be collective knowledge, but that's what you think the officer, when they type it on the computer, that's what they see.
That's the memory of that's what the officer testified to as his memory, and there was not more information before the court at the time of the hearing.
Can I go back to Oscar? Because I want to clarify something, at least in my mind. The police report doesn't say that Oscar said, I don't want to tell you because I've told you everything I know. That's not what happened. They call Oscar and he states, quote, he would not come to the station as he needed to pick up his wife and was not forthcoming to SM blah blah dispatchers with any further information. So he doesn't say anything about I told you everything I know. He just says I'm done. I'm not talking to you anymore.
That's
Right?
what Your Honor cited at the first sort of first instance
Quote.
of the police report is accurate. And that further in the report where it's documented that later contact, that 5 days later, it's at that time that Mr. Flores reports, and it's memorialized in the police report, that he has nothing further to add and declines the invitation to come in and speak
Oscar
further.
stated that, quote, he has nothing further to add and refused all requests to come to the station.
Now here's why I ask about this. Brandishing. The judge, in a finding, and we'll talk about that in a second, said that he brandished it towards Oscar. And you in your report, in your brief, talk about that's an assault, which if he had brandished it to Oscar, that might be an assault. Where did that come from? That's not what Oscar said. He said and again, there's also a language barrier, but we'll put that aside for a second. He just says he sees 3 men, they were smoking, blah, 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 and at one point brandished a firearm. We don't know if it was to him. We don't know if they were somebody was waving the gun in the car. Brandish just means show, doesn't it? Or are we going to interpret what Oscar, through a translator, meant brandished meant?
Recognizing this court can review the police report de novo as documentary evidence, I would point out that it was not challenged at the motion to suppress that brandished meant brandished, as in threatened or displayed menacingly towards someone. Counsel didn't object to that.
Towards someone?
Towards Oscar. Counsel never objected to that characterization.
What kind of question could that be asked? Nobody was there who spoke to Oscar. How can you ask a question of the officer who, I don't know, read the police report? What did Oscar mean by brandish? The officer who wrote this report was somebody from SEMRECC, whatever that means. Nobody was on the witness stand from them to say, what did Oscar actually say?
I think because it's not in contest, that from that document, it's readily inferable that it's a threat of a
So how could somebody
firearm.
argue it? Those are the words that are used, brandished. It's been interpreted by the judge as brandished to Oscar. That's a fair inference?
Yes, particularly where the information about what Oscar's reporting appears to be his firsthand observation, and he's the party that, observing this, was prompted to call the police.
I don't dispute that at all.
3 people are getting high in a car that's driving erratically on the highway. Isn't it possible one of them pulls out a gun to show it to his buddy? Hey, look at this, it's shiny and silver. That'd still be brandishing, right? If someone saw it from outside.
I think it's important to look at the terms that were used, describing weaving in and out of traffic, and not just the conclusory language of operating erratically. In terms of what is most readily inferable from the police report is that this was brandish in the sense of a menacing display of a firearm at Oscar.
The second paragraph of the report, though, says, however, there was a very strong language barrier while communicating with Oscar. So you want us, please don't, I get why you're saying it, that Oscar, who has a language problem, is using the word brandished, and he's using the words operating erratically by weaving in and out. Doesn't that sound a lot like police talk? As opposed to civilian talk, who, by the way, has a language barrier?
So I think it's important to look at what information Oscar was able to provide. So understanding that it's written in ink, an observable language barrier. Look at the information Oscar was able to provide about the car, about the occupants, about their activities, about their travel, about his own path of travel. There's nothing that
It was a
suggests it's a
continuing
profound-
conversation.
I'm sorry?
It was a continuing conversation. The police report makes that clear. They dispatched the officers from Foxborough, and they then get on the line with SEMREC, and Oscar's still on the line. He's describing where they are, where they're going. There was some length of time to this. He got their license plate. It was right.
And for those
Right.
reasons, I would suggest
And we're talking about reasonable suspicion here.
and it's on those facts that Your Honors pointed out that I think that quell potential concern that brandish didn't mean what brandish.
Okay, we can get back to this, but I want to talk about something else that's important to me. I've rented cars a bunch. I don't know if I've ever rented one for 10 days. So how's there reasonable suspicion that a car that was rented 10 days ago, that you then see on the street, is still being driven by anyone who has anything to do with that?
In answering Your Honor's question, I'll make reference to a question posed by Justice Englander earlier, which was whether the passage of time and dissipation of reasonable suspicion was argued below. And I'd submit that the thrust of the argument below was that the passage of time and the issue of staleness really applied to the information Foxborough
I'm not
learned or
interested
disputed.
that's not what I asked you. I asked you whether 10 days after a rental car has been seen to have someone in it committing a crime, whether 10 days later there's reasonable suspicion to stop whoever's driving that car.
There may be, and here there was.
There may be.
And these facts, Your Honor asked me a general
Okay, yeah, I
question.
want to understand why this is different from some other case.
Because at the time that officers stopped this car, they don't know exactly who is in it. It
They're
started-
never going to know who exactly is in the car.
In this, I'll speak
Okay, but
more
go ahead,
concretely about this
I interrupted you, I
particular
apologize.
case, that when officers encounter the vehicle in Boston, at that time, they have no idea who's in the car. That's in the record. They know that it's a rental car, and they know that ostensibly, they're the first police officers to encounter it because there's no queries that have been registered in the time between the police report of the crime and the stop that they're.
So they know that the original police officers what?
There's no inquiries on the vehicle. They appear to be the first officers encountering it because their
Okay,
terminal
all right,
reflects
fine.
no inquiries
That's fine.
in the time between the report.
But the
of
original
crime.
police had the license plate. Well, I mean, they could have done further inquiry, but whatever, the car was gone and they didn't, so all right.
So what I mean by no further inquiries, I mean they appear to be the first officers to on-site this vehicle and run the plate and therefore investigate the BOLO.
Okay.
That there's not information suggesting some other officer exhausted the BOLO by making contact with the driver during the period.
Yes, it's an open bolo. I don't know what that is. I don't know how long you keep them. I know nothing about that, but clearly there's still a be on the lookout. It's 10 days old, but it's there.
Right, so.
And it says it's for brandishing a gun.
Yes. And at that point, though time can affect the presence of the validity of reasonable suspicion
Sure.
such that over time it can dissipate, the question becomes whether or not it evaporated by the time officers.
That's why I asked you if 10 days after it was seen and it's a rental car, whether there's reasonable suspicion.
On
And
these
you didn't
facts,
say
yes.
yes, you said there may be. When is there not?
I would suggest it becomes less so if officers are looking at a car and there's information contrary to the reasonable suspicion report, right?
So if there was only a white guy driving the car and they could see through the window that it was a white guy driving, then they wouldn't have reasonable suspicion because in this report, it says there were 3 black males inside.
it might require more information to particularize the occupant. at
Did
the
they
time
say
of the
they knew,
happening.
did they say they knew the race of the driver when they pulled him over?
No, and I think that that's
Okay, so now
relevant.
you're just pulling over a 10-day ago, a rental car that 10 days ago was involved in something. You don't even know if the driver is the same ethnicity as the people who committed the crime.
That's right.
But there is reasonable suspicion to stop him,
The car, yes.
not the car, him. I don't care about the car.
to-
If you wanted to tow the car off the street because you thought it was evidence of a crime, which you haven't said, that might be one thing. This is, you're stopping a person.
In order to confirm or dispel suspicion at the time that whoever is driving this car at the time the officers encounter it, in order to confirm or dispel suspicion that they're affiliated with the crime report, they have to stop the car.
A month later?
I don't think that's unreasonable on these facts.
Oh, a rented car, a month later you can pull over.
There's no,
6 months.
it's no bright line rule. It's a test of,
Reasonableness?
yes. And that's, rightly what the judge recognized below, that at some point, the information becomes of value such that officers can no longer act on it. And he did not find 13
Would it matter if
days-
it was an Avis rent-a-car rather than whatever this company is?
I'm sorry?
Would it matter if it had been rented from a different kind or different rental company that's well-known for airport rentals and things like that, Avis, Dollar, Budget?
Without information suggesting that it is no longer rented by the person who had it at the time of the reported crime within the past 2 weeks, I don't think there's an assumption that it's no longer the person.
So I see. So the assumption is rental cars are always being driven by the person who rented them whenever the BOLO went out, regardless of how much time passes.
I am not taking as an extreme position as that. I'm saying that 13 days is not patently unreasonable.
I've never rented a car for 13 days.
Mr. Gary did for over a month.
Fabulous.
Those are two factual accounts and.
I agree with that. It's a question, though, of the likelihood that this points toward this being someone having to do with the crime. If it was his own car, I think you'd have a stronger case. But it's a rental car.
It is, but at the time that officers are stopping it, much to Justice Englisher's earlier point, the only way to confirm or dispel suspicion that the driver at the time of the
That
stop.
doesn't give you reasonable suspicion. Yes, I agree, they should have done more investigation. That's fine. But they confirm or dispel suspicion that it's still rented. There's no other way. I know a way. Call the rental company and see when it was returned.
I would submit that on these facts, the officers acted very reasonably and proportionally, and that their very first question
But they
upon
have
pulling
to
over the
have
driver was
reasonable
asking.
suspicion. I agree with that, and if they'd known that before, I mean, you see my point, but I don't want
I do
to,
have
there are more questions, I think.
Well, one maybe. not.
Whatever, we've got,
The brandishing, again, I go back to it because there's case law, KOTOR from 1990, that says the possession of a gun alone is not sufficient to give rise to reasonable suspicion. So your brandishing's kind of important, isn't it? Because if it's not an assault, somebody is just possessing a gun in the car, and that's not reasonable suspicion. It's not reasonable suspicion to stop a person. It's certainly not reasonable suspicion to stop a car, right?
Mere possession of a firearm, a visible firearm, no. Agreed.
So we really have to interpret brandish the way you want us to, or else this is done, right?
Where it's
Erratic driving's irrelevant?
where it's compounded with use of, observable use of substance and driving erratically, no, I don't think it's as plain as that, and I don't think there's a reason to question the validity.
is it
of
illegal to smoke marijuana in a car? I don't know what the new law is.
It would be to be operating
You're the driver.
If you're the driver, yeah. Okay.
or in possession of a firearm while under the influence of an intoxicating substance.
And this is my last question. The exit order. Justice Englander made a great point about the first question that one of the officers asked is, how long have you driving? Before that officer asked the question, I don't know if you watched the videos, there's an officer yelling, get out of the car. So what do we do with that? They were pulling that guy out of the car before they even found out if he was driving it a week or 2 weeks earlier. So what do we do?
I think the subjective intent, Your Honors, deriving from the second officer's behavior that's on the video, I think the subjective intent of that officer doesn't disturb the objectively reasonable basis from which Officer McDonald conducted his inquiry of Mr. Gary and ultimately asked him to step out of the vehicle.
But there's an exit order. The officer is yelling, get out of the car, before anyone finds out about when he drove. So don't we have to look at whether the exit order was proper?
So if Your Honor is looking, I think there are two camera views that are most instructive, the two officers who were conducting the initial stop. And Your Honor's pointing out the behavior of the officer on the passenger window, which was rolled up, and the judge observed that. Review of the camera footage of the officer, Officer McDonald, conducting the exchange through the open window with Mr. Gary. You see that Mr. Gary's exchange with Officer McDonald isn't disturbed by the other officer's behavior. Officer McDonald and Mr. Gary are conducting their exchange. There's Mr. Gary's on a phone call with someone as that's going on. So an officer's subjective intent expressed, kind of on the outside of what is happening between Officer McDonald and Mr. Gary doesn't disturb the objectively reasonable inquiry that Officer McDonald was conducting and the exit order that followed based on Mr. Gary's identifying himself as the authorized user of the car during the relevant period for a crime involving a firearm and his initial noncompliance, lack of cooperation, giving rise to concerns for officer safety in that context. I appreciate the time. Thank you, Your Honor.
Thank you very much. Sorry
Very
for
well
keeping
argued on both sides.
Longer, excellent arguments on both sides. Thank you very much. The case is submitted, I'm supposed to say. And so I have. Our next matter, if I'm doing this in the right order, is number 22692, Department of Children and Families versus Mother. I will remind all counsel and the panel that this case is impounded and therefore everyone shouldn't use names referring to them as child, mother, and so on. I gather the appellees will be splitting their time. I have the department 10 minutes and then the child 5 minutes. Is that what we're doing? All right. And we will first hear Attorney Commandul for the mother.
Good morning, Your Honors. May it please the Court. My name is Tara Comendel, and I represent the mother in this matter. The mother would suggest that you vacate the judgment and remand the matter, Your Honor. This is a case about the lower court's failure to choose between two competing plans. And at the same rehearing, a reopened evidence hearing ultimately a year later, failed again to follow the requirements under DORA.
Could you move the mic a little closer to you?
I think it's my voice.
That's okay.
Under DORA, failed to follow the requirements under DORA, Your Honors. DORA requires that the court consider the adoption plan proposed by DCF before terminating parental rights, consider the parental nominations of caretakers, and then determine which placement will serve the child's best interests, and meaningfully evaluate both plans. DORA does contemplate, Your Honors, the issue of harm to the child by being uprooted, and the issue of insufficient evidence required to consider both plans. I recognize that I would be asking this court to do something that hasn't been required yet, but I would suggest that Hugo does apply in this situation. Hugo had expert testimony regarding any potential harm to the child from being removed from a department-placed.
So you're asking us to extend Catherine to the circumstance of competing plans?
Your Honor, I briefed that, Your Honor, and I understand the constitutional right that the parent has, and that's where Catherine comes in and says, yes, you've got to get these extra findings regarding the harm and whether mother or the caretaker was not able to remedy those harms. I would suggest that here, given that one of the placements is kin and a family relationship, that this court could adopt Hugo and reason through Hugo that the lower court did not have sufficient evidence to.
Because of the absence of an expert?
I would suggest that, Your Honor, and also they're absent on findings of any harm. The findings below, even the supplemental findings, are absent regarding any harm to the child from removal from the home she had been in so long. And
So to pick up on that, because that was one of the questions. So you're not saying that the judge made any errors in the findings of fact. You're saying there were more that needed to be included.
I would suggest that the errors are, there's error in the finding by omission, that they don't contemplate familial relationships, they don't contemplate long-term effects, long-term studies that children do better when placed with kin, and they also didn't contemplate the department's own violation of their regulations.
What do you say to the department's response to that, which is, well, nothing prevented mother from putting in that kind of evidence, if that kind of evidence existed? Your position seems to be that the department can't go against kin without having an expert and considering the impact.
I wouldn't suggest that they can't go without kin. I would suggest that when the department initially is aware of kin, they have mandates, and they have 110 CMR that mandates them to consider kin. And
Can I separate these two things out?
Sure.
Because this isn't a motion complaining about the foster placement with non-kin when that placement occurred several years before trial. This is a question of having not raised such an objection and the child having been in this non-kin foster placement for, I don't know if it was 3 years roughly at the time of the second hearing on the competing plans, complaining at that point and saying, and the presumption in the absence of more than is in here, is that you move the kid from what someone might describe as the only home she's ever known, because it is, into the kin placement based on kinship. How can that be the rule?
How can that be, excuse me?
How can that be the rule? How can the rule be if a kinship placement shows up at the time when you're deciding the plan, and the child has been living somewhere for 3 years, that we presumptively, in the absence of expert evidence or some other evidence that isn't in here, we take the child from their 3-year foster home and place them with the kin solely on the basis that, but it's kin who has passed, of course, a home study, but that's all.
Right, that's what I was going to suggest, Your Honor, that I think the legislature and I think the case law has a preference for kin. I know the judge cannot do that.
A preference. And that's I mean, that's all the way through, I guess. But it just seems to me that it can't be, I mean, I guess we could announce a rule. It isn't a rule that has applied to this before. And even the rule in Catherine is only if there's no other evidence except
Correct, it
the
has to be
bond.
the ultimate factor. The bond has to be the ultimate factor. But I would suggest from these findings, Your Honor, it appears that's the ultimate, that's the first finding, is
Well,
the
the
length of
judge
time she's
also
been there.
finds that this aunt didn't, aggressively do anything to create a connection with the child, to further her own asserted claim to a relationship with the child. Go ahead.
And I think, Your Honor, when you tie, and I gave this a lot of thought, Your Honor, when you tie familial rights, biological families' right to visit, right to see the child, right to get information, to a mother who the department has claimed is so unfit that rights need to be terminated, it makes that very tenuous for family members to come forward. Also,
Understand that point. I lost you when you started talking about familial rights, because there aren't any for aunts. And,
correct. What
so
I'm saying is,
I lost you, but what's the concept that?
when an aunt, not a grandparent, but when an aunt would like to visit with a child who's in DCF custody, that has to be cleared through DCF. So they request that, and oftentimes they're told, you can visit when mom visits. So the result ends up being, if mom is not visiting consistently or mom's not visiting, that aunt doesn't have access or have visitation. So I think
Right, but presumably, and this kind of comes through the judge's findings, presumably the aunt, if she wants to adopt a child because she sees this coming, could say, I'd really like to meet with the child. Depending on how this works out, I'd like to have a relationship with the child. But there's no evidence that this aunt did that. And in fact, this aunt did not present herself as the kinship placement for over 2 years.
it was, she
Or
certainly.
nearly 2 years.
Correct. And what happened was she was reliant. I would suggest, Your Honor, that this is a family that was not. If the department told her to wait for an application, she waited for an application. So.
No. There was another aunt who they had agreed was going to be the kinship placement until something like October, September of '21, right?
2020, Your Honor.
2020, yeah, that's right.
So, yes, and between the two aunts, who I think both were approved, there was a family discussion regarding that. But I would
Okay.
suggest, Your Honors, that that's not too late. It's certainly not 6 years.
It might not have been too late, 2020. And the mother was represented by counsel. I mean, I have to say, and I don't know how to fix this problem, we routinely see objections at the very terminus of these cases that somebody should have raised years before. Reasonable efforts is the obvious one, right?
Your Honor, yes,
And
Your Honor.
I'm sure people are overwhelmed with these cases, and these are the most difficult cases we see. But if someone doesn't ask and then when told no, go to a court, we wind up having a pretty hard time, because now we're talking about a 4-year-old who's been in a house for 4 years, knows who the aunt is, essentially, and maybe thinks of her as her aunt, and is going to be like, and now you live here. And that's not too great.
I understand, Your Honor, but that's where the expert testimony comes in, that I would suggest that some kind of information should have been.
I don't know, 4 years, when does it get to be the most famous, what was the famous case about this in the 90s, Baby M? And that was about a mother who had not consented to the adoption, and it was still a huge national debate because the child, I think that child might have been 5, not 4.
And I think that's also, Your Honor, another consideration, is that children, we're making these, this child isn't 12 or over and can certainly say where they would like to be and give some evidence that way.
Well, God willing, this child will not be unadopted when they're 12 or over.
Correct. Or, I would suggest that that is where the error is in the findings, in the lack of consideration
So the rule
of those
that you
things.
would want us to adopt is that the department, when it had this meeting, the one you talk about with the 3 people to basically decide what they were going to recommend.
That in
They needed, it was error for them to reach that conclusion without first speaking with an expert on bonding.
I would suggest that, yes. I would suggest that if DCF controls placement, then are aware of kin but chooses not to place with kin and chooses a non-familiar foster home, and then at each step, knowing kin's available, continues on that path, I would suggest that, yes, there needs to be some independent expert opinion in terms of whether moving this child is feasible, if and when we do move the child, what needs to be done. I think a clinical expert. And often, Hugo has, he had the benefit of having expert and lay testimony. I think the case cited by the child's attorney, Chiara, had the benefit of
What is
expert.
the regulation that you say that they violated? What does it say?
The department, 110 CMR 1.08, I have it.
What does it say?
It
That the
says,
presumption shall be in favor of kin? Exactly how does it say it?
so they can do an initial eligibility screening, which at any time, they didn't have to wait for a home study for this aunt. They could have technically placed with her. But I'm trying to find exactly where it's within my brief, but
I'm looking for the language that I understood to be along the lines of that when you're looking at the factors as to where you place a child, like the very first factor is whether the child can be placed with kin, or something
Yes.
along those lines.
I believe it's probably 7.100, which I don't have with me, but it's cited in my brief. So I would suggest that it's 110 CMR 7.100, in that when an out-of-home placement is necessary, there are those 4 factors. That number 1 is placement with kin. And then there are other provisions under 110 CMR where once kin is made known, I would suggest that this aunt was known from the beginning, that they could do an emergency placement. And whether a move was feasible at that time or not, that determination was made solely by a social worker, so.
Okay.
And I would just suggest also that also in regards to the findings, the department did violate its own regulations regarding kin in terms of not placing or considering the aunt prior to the home study. They had known she was already approved through the probate court. She was caring for 3 other children in her home, and also the findings are silent on any relationships with cousins. This child would be living with cousins, and any family relationships there that could be fostered. And I see I have short on time. If there's no other questions, I would rest on my brief.
I see none. Thank you very much.
Thank you, Your
Excellent argument. We will hear next from Attorney Golke.
Thank you, Your Honors. Grace Golke, Assistant Attorney General, appearing on behalf of the Department of Children and Families. Your Honor, we would ask this court to affirm the orders of the juvenile court, including the second order as to the choice between adoption plans, which placed this child with the family that she has now been, as of today, 5 years with them since she was 4 months old. Your Honors, the question of whether the rule in Catherine could be extended to competing plans, I think that would actually be quite contradictory to Hugo, which came 4 years after Catherine. Hugo specifically looked at the difference between the Catherine factors and the factors that a juvenile court considers when looking at competing adoption plans. It described that because in Catherine, when you're looking at termination of rights, there is a right of the parent, that's quite distinguished from a situation between two competing plans where there's no thumb that's meant to be on the scale of either the department's or the parent's proposed plan.
What is the regulation about kinship? Does it apply to pre-adoptive, not just foster placement?
Yes, Your Honor, the department does have a preference for kin placement throughout.
Do you have the regulation? Because I'm looking at 110 CMR and I'm not.
Yes, I believe I'm looking at Mother's brief here on page 33, which is citing 110 CMR 7.101 about out-of-home placements, and that the department shall consider consistent with the best interests of the child the following placement resources in the following order, starting with placement with a kinship family.
The department, I'm looking at that, the department shall consider, consistent with the best interests of the child, the following placement resources in the following order. A, placement with a kinship family.
Yeah. Yes, Your Honor, and I would posit that is what the department did here. It did consider whether there was an appropriate kinship placement. Earlier in the case, it was a separate great aunt who was coming forward. The great aunt who has now come forward at that time had expressed to the department that she was seeking custody of a different child, and so that great aunt had made a decision at that point that she was not going to be considered a placement for this child. So it would not have been appropriate for the department to place her in that care at that time. By the time this great aunt was coming forward in October of 2020, that's in the juvenile court's findings, that was the time at which this great aunt came forward. The child was about 2 years old at that point. This great aunt still had to go through the home study process, and so the department did follow all of its regulations. Once it had identified kin who was interested, it followed that proper procedure, and unfortunately due to COVID, that took a little longer than it normally would have, but the department did not ignore this application by any means. It did consider it, and ultimately it came to the conclusion that the current placement in the foster home was in the best interest of the child.
Do we know why they didn't place with the other aunt on a temporary basis?
Your Honor, I understand from, this I believe is in the supplemental record appendix, that the other aunt had filed an application in October of 2019, but she had filed it with her husband, and there were some questions about whether the husband in fact was open and interested in being a placement, and so there needed to be some additional information and interviews to determine if that was in fact everyone on the application was open to this placement.
That wasn't filed until October of 19?
Correct, that's
When was the, I'm just trying to get the timeline, when was the motion, the abuse of discretion motion, when was that filed?
It was filed, it appears in about September of 2020.
So a year after this other great aunt applied.
Correct.
So when that was filed, the current placement that mother is now suggesting was not, when the abuse of discretion motion was filed, it was to place it with the other aunt.
No, Your Honor, it was to place it with this current aunt. So the, if I could give you a quick timeline.
That's when they switched.
Yes, Your Honor. So
September 2020.
Exactly, Your Honor. The other aunt withdrew her application in January of 2020, requested a new application in April of 2020, but ultimately did not submit a new application. It appears at some point over the summer that the family decided to shift efforts to the current great aunt, who then ultimately submitted an application in February of 2021.
Okay.
After this abusive discretion hearing took place, and ultimately that abusive discretion motion was withdrawn. When counsel withdrew, it was not refiled. And so I think as your honors recognize, the department's position is that would have been the appropriate mechanism to bring this to a court's attention, to have it timely addressed, rather than now, with this child having spent 5 years in this home where she is thriving, she is happy, she considers that her family, to now use that pattern or that prior behavior to try to call into question the juvenile court's consideration of the evidence and the juvenile court's weighing of the testimony, weighing of the credibility of the witnesses before her. There really is no basis for this court to overturn the juvenile court's decision based on what occurred with the family members and the department prior.
Do we know if at the time of the motion for abuse of discretion that was ultimately withdrawn, do we know if the child opposed or took any position on that?
Your Honor, I believe the child's counsel at that time said that he was sort of reserving judgment and wanted to hear the testimony. I may be confusing that with the reopened proceedings, but I believe the child was not taking a position, but perhaps child's counsel may have more detail on that. Your Honors, I would just encourage Your Honors to look at the both orders of the juvenile court, particularly the supplemental order from April of 2023, and see that the juvenile court did consider and meaningfully evaluate both plans to determine what would be in the best interest of this child, looked at a number of different factors, none of which were dispositive, and found that the current placement was in the child's best interest.
Can a judge know, is it because it's common knowledge or something? Can a judge know what the consequences are of removing a child at a particular age from a particular home to another home or whatever? In this case, they know the person, maybe know them as their aunt, but they haven't had real substantial contact with them. How is the judge supposed to assess that without someone coming in and saying, this would be really bad, or, well, actually, if you whatever?
Your Honor, there have been a number of cases where a judge has chosen a foster placement over a kinship placement without expert evidence. I'm thinking
in which the court was asked, in which the court held that doesn't matter?
No, Your Honor, but with no expert evidence. So where the court.
Okay, but I'm asking, if no one's ever argued it before, then it doesn't matter what happened in cases where it wasn't an issue. I'm asking, doesn't a judge need that? I mean, how are you supposed to know how strong are the bonds? What would the consequences be? I mean, my complete lay guess is, moving someone from the only house they've ever known when they're 3 is probably not great. Maybe catastrophic. I have no idea, but I have no idea.
Well, Your Honor, the judge hears testimony, for example, from the adoption social worker who testified to the child's behavior in the home, the child's bond. So I think there is a certain level of common sense for the judge in knowing what type of relationship the child currently has, what the consequence would be of taking the child out of that relationship. Even in cases where bond is used in considering termination of parental rights. Adoption of Daniel said.
How big a deal would it be if the child was 6 months old?
Your Honor, it would probably be less, I think, at the time.
How about at 1 year?
Certainly there's no bright line.
But shouldn't a judge therefore, I mean, since I don't know, not that I'm like whatever the platonic ideal of a judge or anything, but I literally don't know. These seem like complicated questions.
Take judicial notice of that.
That I don't know, or that I'm not the platonic.
I'm sorry.
Well,
I'm sorry. A little levity was
arguendo.
unnecessary. I apologize.
Your Honor, I think a judge can consider if they feel they do have that knowledge. I think in this case where you have a child who is showing the bond, who is calling these foster parents mom and dad, there is evidence in the record that is quite concrete about what the bond is for this particular child.
But it's your burden. It's not
Yes.
like if the judge can't tell, they ask for more. You have to give them what they need.
Well, Your Honor, I would say on the competing adoption plans, it's the department, there is no burden on either party to support their adoption plan. What we have moved, after we've moved past termination, the juvenile court is making an even-handed assessment of the proposed adoption plans.
I'm sorry, I don't know what that means.
My understanding of the law is that at the point where we're making a best interest determination, so assuming rights have been terminated, we're now making a best interest determination. The department has put forward a plan, the parent has put forward a plan. The juvenile court's role at that point is to assess both plans.
Well, but presumably, I mean, there's always got to be a burden of persuasion, or, right? Or where does the tie go, right? So presumably, you have the burden to show that your plan is better, and the opponent has the burden to show their plan is better. I mean, I have no idea. You're the proponent.
I suppose you could look, I have not seen it presented that way in any
Have you
cases.
ever put in no evidence and let the judge decide what she needs? I bet not.
I highly doubt that, Your Honor. I think that,
The department makes a recommendation.
yes, Your Honor. The
Okay.
department makes a recommendation, puts forward their plan, but the role of the juvenile court is to act as a neutral arbiter between the various plans. That's the way it is presented within the case law, as opposed to the
I guess it's
termination
not.
decision.
I'll have to look at that. I've never heard of a judge with no burden of proof, but.
Yes, Your Honor, I would look at adoption of Hugo lays out the standards. That's how
I
I
will
would
look at
understand the
that.
standards.
Okay, your time has expired. I see no further questions, so we will hear next from Attorney Farino, whose name I have also mispronounced. I'm going to just start saying Smith and acknowledge that that's wrong.
Good morning. May it please the court, my name is Sandra Ferrigno. I represent the child. The child requests that this honorable court affirm the decrees issued by the lower court finding the mother unfit, and that the DCF plan of adoption by the current foster parent is in the child's best interest. As you heard earlier, the child was 6 days old when she was placed with this current foster family. She is 5 years old currently, but today is her 5th year anniversary with this family. My sister has thoroughly addressed the majority of the arguments I was going to make this morning, but I did want to clarify just a few things. Justice Englander, you had mentioned that there were 3 people present at the ACRT meeting. That actually, what happened was the social worker testified that he was there with 2 other people, his supervisor and her supervisor, and he could not recall the other people that were there. On cross-examination, he actually testified that there were other people present at that meeting. He just could not recall who they were.
But none of them were an expert, or none of them were people who would bring particular expertise with respect to bonding decisions under the circumstances, right?
They were clinical parties. So there was the reason that he asked for that ACRT meeting initially was to get some clinical recommendations about what to do.
And we know that how?
He testified to that was the reason for him requesting the
So I take
clinical-
it from your answer that you're not willing to, you're suggesting by your answer that there were people with expertise in the room with respect to issues like how much bonding would there be after 5 years? How important would it be to be placed with kin?
I'm only suggesting that there were more than 3 people present at that particular meeting.
Does the child have contact with familial relations?
Yes, the child does. And also, it is very important to the foster family, and foster mother testified at the remand hearing that she is open to maintaining contact with the family moving forward. The other issue that I wanted to bring up is that the mother did file that AOD hearing back in September of 2020, and the judge left it open to successor counsel who was present at the withdrawal, the motion to withdraw, and the mother's counsel just never refiled. And as Justice Rubin pointed out, that was the best remedy with respect to.
Did the child take a
addressing that.
position on that motion?
Initially, no.
Eventually?
Eventually, yes.
And
At the remand hearing, the child's position was that she wanted to remain where she was.
The remand hearing, not on No, the remand hearing is about the permanent placement. I'm asking about the abuse of discretion order. When that motion was made, there was no point at which the child expressed a position on that motion?
That's correct, Your Honor.
Okay.
Child's counsel stated that he wanted to hear the evidence.
Did you represent the child throughout?
I'm sorry?
Did you represent the child throughout?
I did not, Your Honor.
Okay.
The child is still in this placement?
Yes, Your Honor.
How recently have you met with your client?
A week and a half ago. So, in closing, she has been in the same loving and a stable home since she was 4 months old. She is very happy and content to be there. She wishes to remain there and to be adopted by that family. She is connected to the family members, and the foster family is open to maintaining contact with the biological family, including the aunt. If there are no specific questions, I would rest on my brief.
I see none. Thank you very much
you.
for an excellent argument, all of you. These are, as I said, the most difficult cases we see, given what's at stake. So your arguments are incredibly helpful to us. So thank you very much. The case is submitted. We're going to keep going one more?
You want to do one more? It's up to you.
One more? Yeah, that's the plan, but, okay.
No. We can do this. I'll try to tough it out. It might be good to take a quick break,
You want to take a quick break?
like a real quick break.
All right. We are going to take a brief recess before hearing this case. So for a few minutes at least, we stand in recess. The next matter we will hear, the next matter we will hear is number 23594. It is Sunrise Equipment and Excavation versus Construction Management and Builders. And we will hear first from Attorney Hamer.
Good morning. May it please the court, my name is Robert Hamer. I represent Sunrise, the client in this fee dispute. I'd like to begin by assuming for purposes of argument that the contingent fee agreement here was properly executed. The contingency that's contained in that agreement was not satisfied. The judge found that it was satisfied by the receipt of judgment. To the contrary, the plain language of to the extent it's plain, the contingent fee agreement provides for 1/3 of any gross payment or any lump sum settlement received by the client by way of judgment settlement.
Okay, no, you do it.
Yeah, well, we're probably all going to be on the same place, but I'm going to preface this by saying I think your brief is extremely well done, and I understand it. But when you say the contingency was not satisfied because there had been no payment, okay, do we have to construe the agreement that way? Or could we construe the agreement to be that the contingency was satisfied once he had gotten through judgment in the trial court? Because the agreement seems to indicate that once he's through judgment in the trial court, any appellate work is going to be paid for separately.
That would increase the amount of the payment that would be due, but it doesn't change whether or not the contingency was satisfied.
Well, see, yeah, that's really interesting. You caught yourself right in the middle of the sentence, didn't you? Because no payment is due until money comes in, right? But is that what you mean when you say the contingency hasn't been satisfied?
Well, the case law deals with whether the contingency is satisfied before the client relationship is terminated.
I understand.
And it was not. And if you look at it from the standpoint...
That's only if you assume that he hasn't completed the work that is contemplated prior to the time that he's terminated.
Let me suggest a hypothetical way to look at this that may illustrate the point. If the judgment enters in itself, the judgment's a piece of paper, there's nothing to split, there's nothing to share, there's nothing to take a third of. If the matter ended there without payment...
He can't be paid.
There's nothing from which the payment can be made.
Agree 100%.
So the essence of the contingency is the receipt of payment. It's got to be because
But wait a
otherwise
minute.
there's
For present purposes, though, let's say I agree with you that for the fee to be due and the contingencies to have been met, the client has to, the lawyer has to win a judgment for you, and then you have to collect the money. And that's how we'll know that the contingency written in the contract is met. My question is, once the lawyer has done all the work he has to do to earn the contingent fee, why shouldn't we treat that as the legally operative moment for saying, if and when you decide to terminate this guy, he's not going to have quantum merit. If you collect the fee, he's going to have a third of it. He's done everything he has to do. There are some things that are not in his control, like will the defendant declare bankruptcy, abscond with the funds, die, whatever. And if you never get paid, you don't owe. If your client never gets paid, your client doesn't owe anything. But we're not going to do this quantum merit thing, because otherwise, everyone with a contingent fee agreement is going to fire their lawyer right before collecting the judgment, and contingent fees are going to go away.
Well, That would be wrong under the case law for bad faith termination. So
Okay,
setting
but
that
I
aside,
think you have a finding of bad faith termination here, but I don't think we need to go there. I'm saying, why shouldn't we treat, I know the cases use the phrase contingencies, but as a matter of reason, why shouldn't it be when their work is done, their work is done? They have earned their fee, even if the contingency hasn't occurred yet.
I've thought much about that.
I'm sure.
And that would negate or discount everything that happens before this court every day, for one reason. It shortchanges the import of an appeal and arguing the success of an appeal. The receipt of judgment...
It depends how you write the contract. If this lawyer's contingency said, and you must defend it on appeal, and you fired them before they defended on appeal, or they refused to do the work, then you'd have a quantum Merowick case. But in this case, the contingent fee agreement wasn't about the appeal. There's an hourly fee. Admittedly, you wound up paying an hourly fee, presumably, maybe something else, to some other lawyer, right? But in this case, the work was done.
The work wasn't done because there was no payment.
The work of the lawyer was done. Yes, the legal work of the lawyer. Get a payment? Yes, you have to get a payment, but no problem. If you don't owe him anything.
But that's like stopping halfway across the train
No,
tracks.
it's not. It's stopping after this guy's job is done in a relay race.
Well,
He's got to just run and get the judgment, and the rest, if it doesn't get collected, he doesn't get paid, that's true.
But if it stops there, there's no payment, so there's no...
But it didn't stop there.
The way I'm understanding your argument, on any contingency fee case, the lawyer not only has to do the work to get the judgment, but then he or she has to do the reach and apply and maybe an appeal in order for him to have fulfilled his portion of a contingency fee?
It's all about money. It's not, from a client standpoint.
Isn't that changing the way contingency fee agreements have been written since at least 30 years ago when I was doing them?
Not at all, because you can't, there's no value in the piece of paper to a client that says you...
And there's no cost to you.
Well, what do you...
Until you collect the money. Now, if you want your 2/3, you're probably going to go after that, right?
The client, you mean?
Yeah, no, I don't mean you, I mean...
Right, but the client hires the attorney not to get a judgment, not to get the piece of paper, but to get the result, to get the
So the appeal was part of the contingency?
Yes.
No, it's an hourly rate for the appeal.
It was additional money. So it's
By
part of
the hour,
same
though,
agreement.
not for completing that task as part of a contingent fee.
But
Appellate lawyers wouldn't be happy with that.
the contingency wasn't satisfied because if the case stopped after trial, there'd be nothing to divide.
And you have nothing, so it's no problem. And he's not going after you. You don't have any money yet.
Well,
I mean, it comes back to the question that I asked, and I know we're sort of fencing a little bit, honestly, but, you know, this contemplated the contingency was a fee for obtaining the judgment through trial. And then, after that was done, and it's written that way as it should be, in the circumstance in which there is an appeal, you got to pay me $350 an hour. So I've got a contingent fee plus $350 an hour. Now, I can't get paid my contingent fee unless the money shows up, but I'm done, aren't I? At that point, I'm done with what I had to do for the contingent fee because now I'm working for hourly basis.
well, I'd say no. I wouldn't agree with that. The client hires the attorney for the result, and the result is payment from a client's standpoint. Stopping midstream doesn't get the attorney doesn't get the client the result, doesn't satisfy the contingency, because the contingency is the payment. It's the event of payment. It's the satisfaction of the judgment, not the judgment itself.
Where in the contract does it say the contingency that we're talking about is, where does it define contingency as payment?
Well, it begins saying, in addition to the hourly rate compensation referred to above, the attorney will also be entitled to additional compensation depending on the outcome of the case against the defendant. The additional compensation will be, and then the language that I read before, the 1/3 of any gross payment or lump sum settlement client receives by way of judgment, settlement, award, or otherwise, in addition to any expenses incurred.
Depending on the outcome of the client's case, that equates to the word contingency.
It's under the contingent fee category there. So, yes, it depends on payment, and this is obviously a document that the attorney prepared as a fiduciary.
Getting paid depends on payment, but the contingency that allows him to be paid is depending on the outcome of the case. And one could take the position that the case's outcome occurs at judgment. If there's an appeal, there's an appeal.
Well,
I mean, isn't there an ambiguity there?
I don't think there is an ambiguity, but if there is, it's construed against the drafter. Certainly under the circumstance of in a contingent fee agreement,
and the way we
which is
construe it against the
regulated.
drafter is to say, even though you've done all the work that's contemplated by this, you get nothing?
No, it doesn't say that. Well, it doesn't
That's your
say that all.
position. Your position is he gets nothing under this contract, zero.
No, my position is he gets the $74,000 that.
Not under this contract.
Under
this contract, you're saying you get nothing.
Well,
maybe you can get something on some other basis.
That's correct in that the language required by the rule isn't reserved in this agreement. But had it been reserved, this is the argument on the Rule 1.5. Uh, 1.5C7. So the SJC rule requires that the reservation.
If the contingency hasn't been met.
If the contingency hasn't been
So
met.
let's also, I don't know if we need to reach it. Why don't you lose under the Olpert test if it hadn't been completed? He substantially completed his work. And then you have a finding of a bad faith firing that looks supported.
Well, my argument again is that the work is not substantially completed.
It's substantially completed. He doesn't have to do anything else.
That minimizes the import of the appeal, which is.
You can hire someone else to do the appeal or not. He doesn't get his whatever it was. I thought it was $150 an hour. He doesn't get his hourly fee if he doesn't do the appeal, obviously.
Right.
But in terms of earning this 1/3 of the judgment, he has substantially completed that work. Indeed, he's completed it, in my view, but at least substantially.
There's nothing to divide. I keep on coming back to
it. If you don't want to go and try to get your judgment to get the rest of your 2/3, and if he walks out or you fire him, you did, in fact, of course, hire someone else. Maybe at more money, maybe at less, maybe at the same. I have no idea, right? But your client has an incentive to get the judgment that the lawyer won collected.
Right, and my point continues to be coming back to there's nothing to divide. The whole aspect of a contingent fee is.
I agree that until you got that money, there was nothing to divide, but then you did.
Right.
And now there's something to divide.
Right. Let me move on to just a slightly different point that kind of adds a perspective to it. This is not the case where the client pulls the rug out from under the deal after right when you're at the finish line. This was not at the finish line. This was something that happened years after the jury's verdict, as far as the change of counsel, 2.5 years after the verdict, and the court's findings with regard to bad faith. And I know that colors much of the opinion. The findings don't add up to bad faith in the context of the Fortune case, which is kind of the essence of where the bad faith concept comes from, and the kind of pulling the rug out from under the transaction. the court finds there was a breakdown in the attorney-client relationship. And the court finds bad faith on the basis that the client canceled or avoided meetings, of which there was no evidence.
And went in and tried to collect the judgment himself without telling the attorney.
Well, it doesn't say try to collect the judgment himself. It says he went to the clerk's office to inquire what had to be done to obtain execution.
That's correct.
For a corporation which could not act pro se anyway, under the, the most
The question is only, was the individual here trying to not pay the contingent fee? And there's certainly an inference that if you don't tell your lawyer, but you're trying to find a way to execute on a judgment to which he may be at least entitled to a third, that it's, part of your plan.
This is two and a half years after the jury verdict. Client is in difficult financial circumstances and obviously frustrated under the circumstances.
Sure.
So 2.5 years in, and as he articulated, he found himself in waters that he didn't understand. There's nothing dark about going to the clerk's office and asking a question
There's
about
nothing
the status of the
necessarily
case.
dark.
Right?
But
I
the
don't
judge.
understand your comment that there was no evidence about him not coming to meetings, because I just read the testimony this morning, and that's what Mr. Curran said happened.
Well, if I missed it, I apologize for that. I didn't see that. But not coming to a meeting is not the same as
While
bad
contemporaneously
faith.
saying, you're avoiding answering my questions. I mean, this is what his lawyer testified to.
Right, and the antenna going up and all the rest of it. But none of it has anything or references anything about saying, I'm not going to pay you the contingent fee agreement. This is 2.5 years after the deal. If that was the case, that would happen, as Justice Rubin indicated, right after the contingency was done, right after the trial, if that was the contingency.
It might happen when he's in financial straits. If he's flush with lots of dough, then maybe it's not that big a deal. But then there's these litigation loans at some insano rate that I can't imagine.
Right.
I mean, I guess
Can
it's
you clarify one thing for me? What was the size of the loan that he took? Was it just two $40,000 loans?
It was about a total of $80,000, something of that nature.
Yeah. When
But
you're
with
paying 3.2% a month?
Yeah, that's right. There should be a law.
Yeah, I agreed. But regardless, I mean, I guess the point I've argued, and whether successfully or not, but the essence of a client search, when he comes and, especially in these days when every TV show you watch has 3 lawyer commercials that are all contingent fee. The client is focused on a result. And the contingent fee agreements that are put in place are about results. They're not about getting halfway. This contingent fee agreement is a little bit different because it has the nuance that more money is due if there's an appeal. But it doesn't change the essence of the contract, which is that the payment, if any, is going to be due on receipt of payment. Receipt of payment, whether it's by a settlement, by a judgment, before or after appeal, it's the receipt of payment that triggers the whole structure of the agreement.
Okay, your time is well past
My
up,
apologies.
although it's our fault, but thank you very much. You've argued this, as Justice Englander said. Your brief and your argument were excellent, so thank you very much. Very helpful to us. We will hear now, I didn't realize this, from Attorney Curran.
Good morning. May it please the court. Attorney Joseph Curran on behalf of myself as the appellee in this case. Your Honors, in this case, the trial court properly determined that the parties had entered into a binding contingency fee agreement and that the contingency was achieved prior to Sunrise's bad faith termination.
Would you agree that you violated the rules of professional conduct because you didn't have the original?
That was an element, that was an issue that came up during the evidentiary hearings, Your Honor, and yes, the fact that I could not locate the original was addressed. I could not locate it, and I do admit to that.
And and also, you did not have what the rules require, which is evidence that you had sent a copy to your client.
Correct, Your Honor. That,
Boy, if you'd followed those professional rules, there was a whole chunk of these briefs we wouldn't have had to read.
you're correct.
And a lot that the judge wouldn't have had to do.
I agree, and in hindsight, I do wish I had a better agreement at that time in place. As the trial court sat through 3 days of evidentiary hearings, the court did hear testimony from the parties that the client did receive a copy of the original following that very meeting when it was signed, and I do think the court gives credibility to that testimony, and I believe the court found...
What should we do with the fact that, Judge Sullivan sort of, he sort of said, geez, the attorney here violated the code of professional responsibility because he didn't do what this rule says. But I haven't found anything that says that this particular violation means that I can't enforce a contract. What do you say to that? If we were to write this in your favor, we're going to have to say, yep, there was a violation of the code, but we're going to overlook it.
I think to that point, Your Honor, as Judge Sullivan recognized in his ruling that Rule 1.5 contains 8 other substantive requirements, and the court also found that the agreement complied with all those requirements, and that the purpose, as the court stated, is to ensure that clients are not charged exorbitant fees or anything like that, and the court found that in this instance, where all the requirements essentially have been met for the purpose, the spirit of the rule.
Except you didn't have in the clause that's in 105.7 or 1.57, right?
Correct.
Would have been nice to have that one in too.
That was missing, and I do regret that was not part of the agreement. But again, I'd argue the spirit of the rule was complied with.
At what point is there, when there's violations of the rules, that an agreement, an alleged agreement, becomes null and void? At what point do we say, you violated 5 of the 6 rules, that's it, we can't go any further, it's null and void?
I think, Your Honor, that point is a good one. I think that if it's violating multiple sections of the rule, there's the contingency fee is not clearly explained, the mechanism for payments not clearly explained. If those items are missing, then I do agree that it's more problematic. But in this instance, those things were spelled out, and I think that's what the court was really looking at. Was the client in a position to know what he was getting into, in a sense? What am I on the hook here for? And I think the court found that he did know, based on the language, the clear language of the agreement.
So what do we do with your opponent's principal argument, the one that he advanced at the beginning of the argument? The contingency, he says, the contingency here is payment. Until the client receives any money, you don't get paid. You agree with that, I assume?
If the result of the receiving a judgment.
The fact that you got a judgment is not enough.
I would disagree with that because Your Honor's...
The client owes you what, 1/3 of the judgment even though he receives none of it?
He owes nothing if we don't receive a judgment.
No, you got a judgment here for $400,000 plus $73,000, I think, something along those lines. And then by the time it was all added up, it was over $800,000, right?
Correct.
Okay. So is it your position that you get paid on the receipt of that judgment?
My position is that the mechanism for the payment to be received is the judgment itself. And once that judgment's obtained,
I have never heard that, nor can that possibly be correct in my view. The client does not owe you $270,000 when the client has not received a penny yet.
no, the collection efforts do have to be, made, but the result
Are there
per the...
cases that say that?
Excuse me, Your
Are
Honor?
there cases that say that?
I could not find anything on that specific point.
I'll tell you what I think, having practiced for a while. I think you get paid a third of what the client gets, and not more. And if the client gets nothing because he loses on appeal or because the defendant has no money, you get nothing.
Right.
Isn't that right?
If there's nothing received, then I would be entitled to nothing.
Okay. All right. So the contingency, and I'm putting that word in quotes because I'm not quite sure what it means, but the condition precedent to you getting paid is the client receives money.
I would argue that Your Honor, per the agreement, that the judgment has to be received.
But we just went over, again, to put it in plain terms, there's a trial or a settlement. If the other side never pays, bankruptcy, whatever, you don't get paid.
Correct.
So the condition precedent is the client gets paid, then you get paid. You agree with that?
Yes, the client has to be paid before, because we would not be issuing a bill in that hypothetical to be paid, no.
Okay. And we have case law that says that the general rule in Massachusetts is that if you're no longer representing the client, if your representation has terminated, either through your doing or through the client's doing, and here's where it gets tricky, right? Prior to the conclusion of the case, then you don't get your contingency fee. So what do we do with that? I mean, unfortunately, I meant to bring the rule on the bench, and I don't have it. But my memory, because I looked at it pretty carefully, is that language of 1.5, I think it's 7, terminated before the end of the case, right?
Right.
So do we have to define what case means? I guess that's kind of where I am, which is, let's say, again, it's hard to make hypotheticals with this. You represent a client, you start the trial, and for some reason, you have to stop. Are you ever entitled to money in that circumstance under your contingency fee agreement?
Under the case law, Your Honor, I think that before that judgment is reached in that instance, I think the quantum merit issue comes up.
Okay, so in that circumstance, the case doesn't end until there's a judgment.
I would take that position.
Well, okay,
So
judgment.
what if you quit after judgment, but before client gets paid? Do we go to the contingency fee agreement, or do we revert to quantum merit?
I'd argue, Your Honor, the contingency fee agreement, the trigger in that instance is the judgment being obtained and received, which is the mechanism by which you'd receive payment.
And where is your support for that? Because the rule says when the case ends.
I see Your Honor's point there. I don't have specific case law on that specific point.
The problem is the word judgment, okay? Because the judgment enters, and then there are post-trial proceedings, which could end up with the judgment being changed.
Or there aren't.
That's a great question, and in this case, Your Honors, the court actually found that I did...
No, there almost always are post-judgment proceedings.
Oh, I see. Yeah, okay, I see. Yeah, of course, you have to do
But
something,
there are post-judgment filings
Execution on
almost
judgment,
always,
whatever,
well,
something.
or
Reach and apply
motion-
pleadings to get the
Motion
money.
for judgment notwithstanding the verdict.
And I had to do
motion for
all of that.
trial.
You did?
I did all of that work. I had to oppose a motion for a new trial, reconsideration.
So can't you understand, so isn't it possible, if we interpret the judgment being the point, those things that you just talked about that you did are after judgment?
Correct.
But you said you did that because you felt, under your agreement, you were still required to, right?
I did, my duty was still in that point.
Well, it's certainly
to-
not the appeal, which is dealt with by a
Right.
previous paragraph.
But there's been a
So
judgment.
maybe it's when the notice of appeal, or when the appeal
Well, I
enters
guess
in our court.
I'm trying to figure out where the line is.
Yeah, that's what I
Is
think.
where the case ends. It's not judgment. We just went through that. And you agree to a point, because you did things more after judgment. So where do we stop?
In this case specifically, I think the stopping point is the fact that the judgment, as Justice Rubin pointed out earlier, the benefit of contingencies would be essentially undermined by a case where you have to go through all of the extra
Not
work.
answering my question. Because under what you just said, the judgment happens. You could say to, they file post-judgment motions. You could say, I'm done. I got my judgment. I'm not handling any of those. And to me, as a former trial lawyer, that doesn't make sense, because there's still more to do even after judgment.
Didn't make sense to you either, because when you wrote the agreement, you didn't say, I get paid separately for post-judgment pleadings. You said, I get paid separately if there's an appeal.
So it's got to be sometime between the
Right.
post-judgment pleadings and the appeal.
There's
Nothing
judgment-
else, this is going to help you
There
write
could
your
be,
next
right.
agreement, isn't
I mean,
it,
it could be when the appeal enters, it could be when a final appealable judgment occurs,
I don't know. And I think that's what the three of us have to figure out, is on that line, judgment being the first one. I think we all agree that that's a pretty good point, and then maybe the notice of appeal being the, but there's a lot in between there. And this case is a phenomenal example of there's a lot in between there, and where does it end?
There was a lot. It was over 5 years of work, and it did not end after the judgment.
And the judgment, the work getting security for the judgment, and the work trying to get execution, and I mean, it's an interesting question whether that is also contemplated by the contingency fee agreement. The fact that the fee agreement singles out appeal work for separate payment suggests, and your own conduct suggests, that you thought that all the post-judgment security and the work getting execution was also included within the contingency.
I viewed that work as, I looked at it as once the judgment was obtained, that I did substantially perform the work under the agreement, but that I did owe, my duty was to continue the work to obtain the payment, which I continued to do by getting reach and apply motions in place and a bond and everything else.
While the appeal was pending?
Yes, Your Honor. And I also had to, had once successfully got the courts to, both the Court of the Appeals and the trial court, to dismiss the appeal because on procedural grounds it was not being prosecuted. So the work did continue all the way up through that point. But in my view, my work had been completed on the judgment, and my duty, though, was to continue on the client's behalf.
Okay, but if the appeal did in the end wind up reinstated and heard, right? So after appeal and remand, or whatever, or the rescript issues from our court, whatever it is that happens technically, that there still has to be something done in the trial court. Reach and apply, maybe, or I don't know, right?
Right.
Execution anyway. And you think that is part of the obligation of the trial lawyer under the...
In handling that case, I did feel it was my obligation.
Okay, that's fascinating. Okay, that's very helpful. Very interesting. Your brother got a lot of extra time, so if there are questions, I'm happy
Or
to.
if there's anything more you want to
anything
tell
you
us.
feel like we haven't.
I can tell you, I think I've got it, but I don't know about The other guy, no.
Unless there's no further questions from your honors, I have nothing more to say.
No,
Arad.
we'll rely on you.
Thank you very much.
Thank you very much. Excellent argument by both of you. It's an incredibly interesting and important case.
Thank you.
Yeah, very well done, folks.
Oh, I should say, we are going to take a recess to reconstitute the panel. We'll be back in, I won't, but the new panel will, in 10 to 15 minutes. And we stand in recess till then. Thank you very much. John,
You can go.